All right, guys, this is just a video to help you have a little bit of an idea of three cases that show up in the cases you can use to help you out in making your arguments in your case. And this information is already on Moodle. I'm just making this video to try and give you maybe a little bit easier way of understanding what happened in these cases. I'm going to look at three cases with you today. The first one is this case called Patrick from 2009. I remember it as the garbage case. The reason why I think of it that way is because it's the story of a guy whose garbage was searched. What happened was the police suspected that this guy, Patrick, was running a homemade ecstasy lab. In order to try and find out if that was the case, they figured, well, we can see if we can get some evidence from his garbage. Let's look for precursor ingredients, the sort of the things you would put together to make ecstasy. If we can find enough information there that shows that he has a lab, then we can go get a search warrant for that and raid his house. And they figured this stuff would probably show up in his garbage if the guy is not very careful, as many criminals often are not. So they went through his garbage, and the way they did this is they went to the back alley of his house, and the way that people dispose of garbage in this guy's neighborhood is that you just put the bags out at the end of the property line, and then the city comes along, takes it, throws it out. Now, the story is that the garbage was actually still on Mr. Patrick's property. So it is in garbage bags sitting there on his property, but in a situation where the police, in order to get at the garbage, they don't actually have to go onto the property. They could just reach over the property line to get the bags from there. So they're kind of in his airspace and taking stuff off his property without actually entering onto his property itself. And so then the question became, well, when they did this, first of all, does this count as a search? And if it's a search, is it legal? Because remember, the police were thinking, okay, well, we want to get a search warrant for the house, and we'll do that by taking information out of his garbage. And so what happened was this case went to the Supreme Court ultimately, and they said that it doesn't actually count as a search, despite the fact that this is stuff that's on Mr. Patrick's property, that them taking this off his property did not count in a search. And the reason why is because there was no expectation of privacy. Remember, it always comes back to that for these Section 8 cases, and the cases you'll be arguing. Is there a reasonable expectation of privacy here? What they said was there may have been privacy in his garbage at some point, like if he had it in his garage, or even further back on his property, he could claim some privacy in it. But that the conduct that he did by putting the garbage bag at the edge of his property, even still on his property, but on the edge of his property, was incompatible with any expectation of confidentiality. The court talks about how people know that, wild animals can go through your garbage, that people looking to get recyclable materials they can sell for cash are going to go through your garbage, street people will go through your garbage. They talked about all this in the court decision, and it's significant if you go back to the main 6 factors that you saw in Edwards, your subjective expectation of privacy. Do you really believe nobody's going to see this stuff? In this case, the court said, look, he can't really have believed that people weren't going to be able to go through his garbage if they wanted to. And because of that, then the police going through it doesn't count as a search. Sure, there's a property line, and that there is an idea of privacy inherent in that, but the physical intrusion by the police over that property line was very peripheral, and if it might have been a different situation if you couldn't just reach the garbage from the edge of the property line. But here, clearly, he wasn't continuing to assert his privacy here. He was really putting it out in a place where anybody could get at it. And because of that, there would be no expectation of privacy. He had actually taken steps as much as he could to abandon it by putting it there so somebody else would take it. So really, he had it. Second case I'll look at with you is a case called Chahil. It's the case involving an overnight flight from Vancouver to Halifax. The story here is that Mr. Chahil decided to take a plane from Vancouver to Halifax, and when he got to Halifax, just before he arrived, the police at the airport there looked at a list of all the purchases of tickets and information on the manifest, the passenger manifest for the flight. And they saw in Mr. Chahil's case that this was a guy who had bought a one-way ticket, not a round-trip ticket that would take him back to Vancouver, but a one-way ticket. The ticket was bought at the last minute. It was the very last ticket bought for this flight, that the guy had paid for it in cash, that he was traveling alone, and that he had checked only one bag. So they looked at all 5 of these factors together, and they said this is really the profile, the specific profile of somebody who is trafficking drugs. So based on this information, they decided let's go and let's bring a canine unit, which they happened to have at the airport at the time. Let's take him to, let's bring this dog and have him sniff Mr. Chahil's checked bag. So this isn't wasn't his carry-on bag. It's not like Mr. Shahill is there at the time. It's not like he's personally present. But this is his bag, which he had checked to go underneath the airplane. And when the dog sniffed the bag, it's indicated that there were drugs present. So the police waited till Mr. Shahill went to go get his bag from the carousel at the airport. Then they arrested him. They searched this check bag and they found 3 kilos of cocaine. So the question becomes, when they bring the dog to sniff it, does that count as a legal search? You might remember we looked at the case where there were the kids' gym bags in the gymnasium. Their backpacks in the gymnasium. And that was clearly a situation where the court went ahead and explicitly said that a dog sniff does count as a search, even if you're not opening it up yet. The dog sniff is almost like an X-ray. It's so precise an instrument. A dog's nose is a highly tuned instrument for picking up smells. So yeah, that's already counting as a search. And before you bring the dog to search something, you have to make sure that it's justified. And they said that, if this were carry-on luggage where you're bringing it onto the plane, there's a lot more security interest in that. If this is just an X-ray where they're checking for explosives and there's a security question, that's different. But here, this was a search that wasn't about anything dangerous. It was about whether there were drugs. And if you're going to be searching on that basis, not for security purposes, but just for drugs, then you want to make sure that the search that you're conducting isn't going to be randomly searching a lot of innocent people. You need to justify reasonable suspicion here that makes it okay for them to go ahead with a warrantless search. Now, the court did talk about the fact that this was in an airport context, which does lower your expectation of privacy to some degree. But they said you still have to formulate some reason that isn't just a hunch or intuition or anything to do with the person's ethnicity that would justify why you're bringing the dog to sniff this specific bag. And they set it out. They say, okay, if you want to justify a dog sniff search, you have to, under the totality of the circumstances, you have to be able to identify specific facts grounded partly in common sense, partly in your practical everyday experience as a police officer, that lead to a suspicion that you can formulate, that you can specifically justify, that meet a reasonable standard. And in the case of Shahill, they said, yes, the police did have enough specific factors that they could put together and coordinate and bring together and say, okay, this isn't just randomly picking this guy on a basis of a hunch. You had 5 factors. You were able to outline the fact that he bought his ticket at the last minute, that he bought it with cash, one-way ticket, traveling alone, 1 check bag. They said, okay, you've put together enough of a case to justify looking at this guy's specific bag. But if you had just done it randomly, that would not be okay. The last case I'll look at with you guys here today is just this case from 2014 called McDonald. This one happened in Nova Scotia. You could think of it as the gun at the front door case. Story there was that there was a noise complaint from a neighbor. They were saying that Mr. McDonald's house was making a lot of noise, so the police show up, knock on the door. Mr. McDonald opens the door, and when he opens the door, he opens it slightly. He doesn't open it all the way. He opens it slightly, and the police is there to talk to him about the noise, and the policeman sees that Mr. McDonald has his hand hidden behind his leg, apparently holding something. So the police officer says, "What's that you've got behind your leg there? What's that in your hand?" Mr. McDonald doesn't answer. He says, "Sir, I need to know, what is it that you have in your hand?" Mr. McDonald doesn't answer. So the police officer pushes open the door, struggles, wrestles McDonald to the ground, and gets what's in his hand. Turns out that it's a loaded handgun. And now the question is, as a way of obtaining evidence, did this count as a legal search? Because now the issue isn't just, okay, not opening the door fully for the officer. That's not actually a crime in this circumstance. But since the officer finds the gun and the gun is in itself illegal, if you want to convict the guy for possession of an illegal handgun, then the evidence for that crime is going to be the gun itself. So then the question becomes, the search by which you got a hold of this gun, is that a legal search? And the Supreme Court says, look, pushing open the door this way, that does count as a search. We are going to apply Section 8 to this and look at it through the eye of Section 8. They say, yeah, you do have a reasonable expectation of privacy in your home, but pushing open the door in this circumstance, they said this is all justified. This is legit. And the reasoning for it is, they say that the search was reasonable because the police have a common law duty. It's not written down in any law. They have a common law duty to protect life and safety, including their own life and safety. If you feel that under the circumstances that the duty is requires you to perform this search, they said if you do it reasonably, then it's okay. Now, they wanted to formulate exactly how it's going to happen. So they said, okay, in order to justify, infringing somebody's liberty in this way, you have to consider the importance of this duty to protect life and safety to the public good, the need of the search for the performance of that duty is the way that you can protect life and safety without having to do this search, and you also have to evaluate the extent of the infringement necessary, right? If I'm pushing open the door to check that there's no gun there, that might be different than if, like, I have to dig up your whole house and see what's buried underneath it, right? So in this case here, what happened with the officer opening the door? He had reasonable grounds to believe, says the court, that the individual was armed and dangerous. And in those circumstances, it was necessary to do what he did. And if it's necessary, then it's justifiable. But it'll be justified only to the extent that it's necessary for the guy to search for weapons. That means he can't say, oh, well, I had to protect life and safety, so I pushed open the door. And then now that he's pushed open the door and he's inside your house, he goes around to every different room looking for anything he might want to find. No. Expressly, all he did was he just searched the guy while wrestling him to the ground, searched the guy for the gun, found the gun. So he couldn't use a danger justification to go fishing for other stuff, but that's not what he did here. And because that's not what he did here, because he limited what he was doing to just searching the guy after he pushed open the door, the Supreme Court says this is reasonable. They said the officer tried to minimize the intrusion by asking what it was. He was trying to satisfy the need for security without having to go ahead and do this, and it was only when it was impossible to do that that he pushed through, that he pushed the door open no more than was necessary, he intruded no more than was necessary, and overall, the way that he proceeded from beginning to end, the court decided it was limited and reasonable, and because of all that, they decided that the search was legitimate and legal, and Mr. McDonald's conviction for possession of an illegal handgun was upheld.